All right, so I'm going to give everyone a couple more minutes.
You've been doing
Good
this for
morning.
3 days?
This is my third. Yeah. So give everybody a couple more minutes. I want to log in. And I've got a couple people here in the room office with us. So we are going to be going over the new forms. The SCR, they did two town hall meetings. They just went over the changes on the listing agreement and the FinCEN. There are changes to multiple forms, so I'm actually going to go over all of the drafts. Um, the biggest change is to the listing agreement, but there are some smaller changes on some of the other forms, and we'll just go through those.
Is FinCEN, is that new altogether or?
Yes.
Okay, I'm having a transaction go through it now, so.
Yeah, FinCEN, it was passed by law back in January, but it went into effect March 1st. The form for it doesn't drop until Monday, the 9th. But we'll go over it again later near the end. That's the last form I'll go over. But FinCEN has to do with buyers that are purchasing a property in all cash, and they're either doing it in the name of an entity, like corporation, LLC, company name, or in a trust. Yeah, and then when they do that, the closing attorney, they're the ones that gather the information and they submit the information. And our job is to let the buyers know, okay, you're going to have to present this. They have 7 days from the time that the closing attorney asks for the information to get it in. If they don't get it in those 7 days, the closing will be delayed until the information is in. If they never turn in the information, it will not close. Okay? It's not a local law, it's not a state law, it's a federal law. Okay. So, and on the form, there's a place to sign for the buyers saying that they've been given this information. And then there's also a place for the sellers because it could affect the closing. Okay. The two that are in here give you the sheet. Okay. Now, the ones that I'm going over, these are just the drafts. Okay, these are available if you go to the NAR website, go to the Forms tab, and you go all the way down to the bottom, and it'll see where you can see the draft versions. Um, but they are just draft versions. The final versions will not come out until Monday. I mean, the drafts do have quite a few errors and grammatical errors, spelling errors, stuff like that. So don't use those yet. Okay.
So my biggest question is, if we already have someone who has the signed listing agreement that's not under contract, do we have to get them to sign a new one?
Not a new listing agreement, no. I've created hey Sarah. Hi Susan. How are y'all? I see them in there. Okay. So the ones that are under listing agreements, if they're not under sales contract, then we'll have an addendum for them to sign. Not going to make y'all go back and redo a whole brand new listing agreement. Okay. All right. So, and if one of y'all would write down Sarah Paul and Susan Withers, they are on via Zoom. Paul, yes. Mhm. All right. So we are going to jump right in. Today, what we're talking about is the updated forms that are going into effect on Monday. Okay. They will drop into the live versions of those will drop Monday morning and they'll go into Sky Slopes at Forms.loop, DocuSign, whichever ones you use. If you have them set up on templates, they will not automatically update in the template. In SkySlope forms, you'll need to go into the actual template and there'll be like a little circle beside the name that has like an I in it. Click on that circle and then it will update. Okay. That is only if it's in the template will you have to actually click on anything. Otherwise, in the regular list that comes up, it'll automatically be updated. Okay. It's just the templates that you have to actually click to update. Okay. So, okay. Why we're doing this training? One, legal compliance. We've got to make sure that we're in line with state, local boards, and federal law when it comes to all of our contracts. Okay. These are the updated contracts. So starting March 9th, you have to use the updated forms. Okay. Compensation clarity. Some of the verbiage in each of the contracts and each of the forms has been simplified. So it's easier for the consumers to understand. Okay. It's kind of, you know how before they were kind of like a lot of legalese in there. Now it's still English, but it's easier for them to understand. Okay. That makes more sense, and especially when we're having to explain it. Okay. Risk reduction is going down too because they are explained better and it's easier for people to understand. Okay. And then it's going to protect your license. And therefore, by protecting your license, it protects my license and protects the brokerage license. Are you okay?
I'm super cold, I don't know. Hang on, I have a sweater here, a
Uh-huh.
t-shirt. But I think it's just me, I don't know.
Mhm.
I was about to ask you.
I'm comfortable, but I run hot, so that doesn't seem.
Hey, Carrie.
Hi.
Hi. We aren't able to see you. Should we be able to on
You'd
Zoom?
only be able to see the slide why this training matters.
Okay, yes, that's what I'm seeing. Just wanted to
You
make
share
sure.
my screen, so yeah, that's all you should be able to see. 'Cause
Okay.
y'all know I don't like being on camera.
I was going to say, are you hiding today?
I am. I am.
Oh, Carrie, you're beautiful. You do a great job. Anyway,
Did
continue.
you and Sarah like plan this since you're both in red?
Yeah.
They're not.
I'm actually in pink.
They're both
I
matching.
know, right? I have no idea.
I'm in pink. I
Why,
can't get my camera to show up.
I don't know. I think Carrie can see me, right, Carrie?
Yeah, I can see both you and Susan. And yeah,
Okay.
And okay,
you both look
Okay.
it's it looks like red for me.
Yeah,
okay,
it is red. I'm
okay.
wearing
Mine's
red.
pink.
Yeah.
I'm pink. Hey, Sarah, I see you, but
Yeah,
I'm not showing up, but that's okay.
I can see you. Yeah, anyway, yeah, go ahead, Carrie. What was
It's
the
easier for
last
y'all to
point? You
put
said
clothes
risk
on
reduction?
than for us to take them off.
Nobody's on it.
Exactly.
It's not me.
Because we can only strip off so much before we get in trouble.
Well, if
Hey,
it's just
Rachel's
women, you should
hot
be
too, so
fine.
it's not
Close the blinds.
just me. So it's not just me.
Just to know that I'm not the only one.
In the winter, we keep our house in like 65, so.
This is amazing, thank you.
That's my girl right there. That is my girl right there. Okay. All right. So what changed overall with the forms? The structure of most of them changed, the language in them changed, and then the compensation has changed.
Great.
But we're going to go through that. Don't worry about it. Got you guys. Okay. I'm not going to let y'all out there. Go just jump in. Like, I got you. Okay. First one we are going to look at is the buyer agency. So let me get down here to my screen. Where am I? Come on. Here's my. All right. Okay. So this is the buyer agent, the exclusive right to buy buyer agency agreement. Okay. This is just a draft. They did not highlight them like they have in previous draft versions or have the little watermark. They just stuck them up there. Okay. So the highlights are ones that I actually did. That's why they look kind of funky. Okay. But what they did, I highlighted each section that did change. Okay. So the first section, and also while we're at exclusive right to buy, there is exclusive agency, buyer agency agreement. Okay. I always suggest that you use the exclusive right to buy because with the exclusive agency, the buyers have an out for not having to compensate you as their agent. Okay. Because if under an exclusive agency, they're driving around, they see a FISBO, they go up, they talk to them, they negotiate it. Guess what? You can get cut out of it. Okay. So that's why I always suggest use exclusive right to buy. Okay. This way, if they're driving around, they see that FISBO, they start negotiating, you're still their agent. Okay. Now, one of the things that was done is that they did add language in here that is easier for the buyers to understand on exactly what their duties are to you. Okay. So, first section that they changed, appointment of broker. So, undersigned buyer. So, this is where you name the buyers. Engages the undersigned brokerage form. There, after that is the broker. So, that's Realty One Freedom through its broker in charge and its associated licensees, you guys, to represent buyer concerning purchase or lease of the below selected real property types situated in the following locations. By appointing broker as buyer's exclusive agent, buyer agrees to conduct all negotiations for the types of properties described in Section 2 below through broker and refer to broker all inquiries made to buyer about such properties from other brokers, salespersons, sellers, and others during the term of this contract. Negotiation as used in this agreement shall mean property shown, negotiated, or information requested by buyer through the broker. All right. Section 2 did not change, but I do want to go over this because this is something that I see as pardon me, as I'm going through and I'm doing the QC on Sky Slope, purpose of agency. Some agents completely fill this out, some don't. I want to give a quick example of why you should always fill this part out. Okay. So what you're going to do, you're going to fill out, you're going to check off the type that they are looking for. They're looking for residential, commercial, vacant land. Other. If they're looking for residential and vacant land, check both off. Check all that apply. Okay. General description, what they're looking for. If they're looking for vacant land to build, put vacant land to build. Home on. Residential, single family residence. If they're looking for a duplex, put duplex. Okay. Approximate price range, put a range. Yeah. If you only put in the number 300,000, this only applies for a property that is 300,000 is under contract for 300,000. Okay. If it's 300,000 and $100, this does not apply. Okay. So range. And it doesn't always have to be all numbers. It can say up to 1 million or 500,000. It can say less than 500,000. Okay. You can use the little less than symbol or the greater than symbol. Okay. You can put a range like 100,000 to 500,000. But make sure it is a range. Okay. General location. Yeah, you want to be specific, but not locking yourself in. So if you put Greenville County, this only applies to a property in Greenville County. If they purchase one in Spartanburg County, this doesn't apply. Okay. So make sure.
Carrie, can we say upstate South Carolina? And
Sure
that covers
can.
everything? Okay.
You can say upstate South Carolina. I've even seen a couple people just say South Carolina.
Oh, you can-
Okay.
Ah,
Because
okay.
Legally,
Yeah.
you can sell anywhere in the state.
That's true.
So
Okay.
I've seen them both. So either upstate South Carolina or South Carolina, one or the other. Okay.
Okay.
If you want to list out the counties they're looking in, great. If you want to just do upstate South Carolina or SC, that's fine too. Okay.
Okay. Great.
And then preferred terms, that's going to be are they financing? Is it going to be USDA, VA? Are they paying all cash? Is it going to be a combination? Okay, that's preferred terms.
What if,
I'm sorry.
so we just put anything possible? I mean,
Yes,
okay.
for whatever terms they're looking at. So I mean, you put if it's all financing, put financing. If it's a specific, if you know that they are, it's going to be VA, then you would put VA financing or something like that, or
Okay.
cash, or combination cash and financing, whichever. However, they're planning to pay for it,
Mm-hmm.
put it in here.
Okay.
What was your question, Lucy?
I was gonna just ask if you could leave it blank, just sometimes they think they're gonna go one way.
Let me explain why you shouldn't leave any of this information blank. And this is going to be a story. Okay. We had an agent a few years ago transfer over to us from another brokerage. Okay. While she was at that brokerage, she worked with a couple and she wrote a buyer agency agreement with them, and she did it for a year. Mhm. During that time, when she was with the other brokerage, they were looking for like a condo or a townhome. They wanted something that didn't have a lot of outside maintenance. They just wanted to be able to deal with the inside. They were an older couple. They didn't want to have to do a whole lot to keep the property up. So they were looking for a townhome or a condo. Okay. So for general description, she had condo slash townhome. Okay. Price range, they didn't want to go above 250. So she had up to 250,000 as the price range. General location, she had upstate South Carolina. Terms was combination financing and cash. Okay. After they closed on it, and then a month or 1 or 2 months after she closed that they closed on it, she moved over to us. Okay. Well, they had been living there for about 4 months, and they decided that they purchased a townhome. It was a 3-story townhome. They realized, hey, we're getting older. Maybe stairs is not a good thing for us. So they decided, okay, they wanted a single family home, one level, with as few stairs as possible. Mhm. So they had a great experience with her. They decided to come back and use her. So they came back. She was with us at that point. She wrote a new buyer agency with them. Okay. But this time it was for a single family home, 1 story. Price range was actually from 300,000 up to 500,000. Okay. But the rest of it was still the same. General location, preferred terms were still the same. Okay. The day it closed, within an hour of the closing, I got a phone call from the BIC at her previous brokerage saying that that commission was theirs because they still had a valid buyer agency with that couple and they didn't release them to transfer. Okay. Here's the thing to remember about buyer agency agreements. Just closing does not negate the buyer agency agreement. Expiration does, or signing a release of buyer agency. Just closing the property they're looking for does not end the buyer agency agreement. She had written it for a year, so that buyer agency agreement under those preferred terms was still valid. Okay.
But she got the commission, right? She filled it out.
What saved us was the fact that the one that they had that was, yeah, the price range and the general description were different under the
Wow.
one that she wrote with us. That's what saved her and us from having to give that commission over. Because because they sent the agency agreement that she signed when she was with them as their is there evidence? I pulled up the one that she did and I'm like, no. But we still had to go through our lawyer, have the lawyer send him a letter and everything. But that is,
Why
this
did-
section is what saved her
Mhm.
from not having to turn over the commission to her previous brokerage.
But
where-
when that big, just obvious, look at it, it's up to 250, like 250 with the cutoff, like it, you know. hello.
They were going by what it was, and so they were trying anything that they could to try to get
Right.
extra money. He didn't pay attention to that.
That's one of the first.
But after that argument, but yeah, because the terms were different, it saved her from having to. And then, yeah. So that section, you may not think that that section is that important, but it actually is. Okay.
It's just for preferred terms, I haven't really. Attention too much to the
Yeah.
preferred terms specifically, because, you know, they say like, oh, we'll be doing cash, and then they. Like something way more out of their budget that for cash, and so then we end up, you know.
And then
never
in that case, if they tell you cash, then I would do cash and or financing.
Yeah.
And that covers all of it.
Out broadly as possible.
Yes.
Even the preferred terms.
Yes.
Because I'm always scared to fill in preferred terms, like that line, and the rest I'll fill out.
Yeah.
Or like if I say they don't want stairs, I've had clients say that and then buy a townhome.
Yeah.
So I'm like, oh.
So yeah, I did.
Yes.
If they're saying stuff like, I don't want stairs, I don't want a pool, or I don't want that, I don't put that part in there. That I leave in my notes
Yeah.
of when I'm looking for properties for them.
And
that-
that would be like the financing.
It could be,
Yeah. I never.
yeah.
That's the hence I left that
Mhm,
line blank as well, just because like,
mhm.
they don't even know what the preferred terms
Yeah.
will be.
So then in
Right.
that case, be broad, and you can always say financing and or cash. That's going to cover it all. Okay.
Okay. Okay.
So the next one, section 5, the next change is section 5. Okay. This is a section where it's consent to disclose dual agency designated agency. Okay. You know, before it's always had the one little line up there where they initial saying that they got the South Carolina disclosure of broker relationships. This one right here. Okay. They added a second one in there. And this was says buyer acknowledges that after entering into this written agency contract, agent might request a modification in order to act as a dual agent or designated agent in a specific transaction. Okay.
So have them sign it.
So they know they need to initial beside both of those. Okay. And then, you know, where currently right now where it has the choices for dual and designated all four together, they actually broke them apart now. Okay. So they have dual agency, buyer to initial one. So they initial both of these, but one of these, either permission to act as dual agent or permission not. Okay. Permission to act as dual agent may be considered. So remind them if they initial beside the one that says may be considered, that is not locking them in to doing that if the situation arises. Okay, it's just saying that if that does come up, they will consider it, not have to do it. Okay. So, and then dual agency, and then at the top of the next page is where they broke out designated agency. Okay. So they separated those two. Okay. So it's a little bit easier to clarify, especially with the consumers. Okay. All right. Section 6, buyer duties. Buyer agrees to view, tour, and or conduct any real estate activity only with broker, which includes all negotiations for the property in good faith and exclusively through broker. Buyer understands that signing more than one buyer broker representation agreement for any overlapping period of time could expose buyer to paying additional fees. Buyer is not a party to any active, exclusive buyer broker representation agreement that has the same terms or scope as Section 2 and or 3 of this agreement. Buyer agrees to allow broker to provide a copy of this agreement to the closing attorney. Mhm. This was in there before, but not in exactly these terms. Okay. So they kind of shrunk it down and made it easier for buyers to understand and actually spells out you can't go sign another one. And if you
Mhm.
do, guess what? You could be paying extra fees.
Mhm.
Okay. Mhm. Number 7, broker fee. Buyer agrees to pay broker as provided below, the broker fee, for any properties involving broker's efforts, which is section 4 of this. Broker's fees will be deemed earned when buyer is under contract to purchase any property presented by broker or negotiated by buyer. Mhm. So when it's exclusive agency, even if the buyer is the one that does the negotiations, you're still the broker. You're still entitled to your compensation, okay? This fee will be due and payable at closing or upon buyer's default. If buyer defaults, the total compensation that would have been due to broker will be due and payable immediately in cash from the buyer. Broker fees are not set by law and are fully negotiable between buyer and broker. This section survives the expiration or earlier cancellation of this agreement. Okay. Compensation. Yeah, they broke it out. Okay. So broker fee, they initial one of these 3. Okay. The first one is percentage one. So if you have negotiated, you and the buyer have negotiated your fee, and it's going to be a percentage of the gross purchase price. You fill out option number 1 and you have them initial beside option 1. Okay. If you've negotiated a flat fee, you fill in the flat fee down here beside the dollar amount, and then you have them initial beside the flat fee. Okay. If it's other, which means it could be a combination of a percentage and a flat fee, then you have them initial beside other and fill in exactly what it is. Okay. 99% of the time, it's either going to be percentage or flat fee. Every once in a while, you might run into a case where it's both. All right. So when it's on this, previously you have been able to renegotiate later on after the buyer agency or even listing agreement has been done. Say you agreed on 2.5% and find out that they're given 3%. You had the ability to, as long as it was in writing and the buyer agreed to it, you could do an addendum doing that. If it's more now, you don't have the option anymore to do that. Okay. If it's below what you've already agreed on, you're fine. If it's above, you're no longer able to renegotiate that. Okay. So when you do your buyer agency agreement, and we're talking about this because this is only Realty One agents here. Okay. Say you fill it out for 3%. And the other side's only given 2.5%. You've already had the conversation with your buyer that if it is lower, then I'm not going to charge you the difference. Okay. Because it's lower than the 3% that you have on the buyer agency agreement, you do not have to go back and correct it, and you're fine. You don't do anything. You accept, take the 2.5 and you move on. Okay.
Carrie, do we need to adjust that though with the closing attorney for the Ulta?
What'll come in is that when they ask for what the commissions are on the other side, then
Yes, that's right.
be told 2.5%, and then whatever the listing agent is getting. Okay.
Yes, that's right.
If you're doing an admin, if you're going to have to turn this in for the admin fee or the bonus section, then at that point you let the attorney know that they are not being charged the extra percentage.
Okay. Okay.
Again, that is up to each of y'all. You run your business the way you want to. If you want to charge that extra percentage or whatever's the difference, it is totally, you are totally within your right to do that. Okay. As long as you have already had the conversation with the buyer at the time that you're doing the buyer agency agreement and signing everything. Okay.
Say, if when you're signing the buyer agency agreement, you really don't know what you'll find or what they fall in love with and what the compensation is on the other side. So say you put your percent down, whatever they end up wanting to purchase is more of a flat, like exact amount. Say they're just offering, just $5,000 or something.
In that case, you are able to adjust.
'Cause you
And
don't
you would
know-
do it on a separate addendum. And it would be specific for that property,
Okay.
for that one property. Okay.
So you can't adjust the percentage if you've already, whatever you signed, like again, if it was 2.5. The house they like is being offered at 3%, you can't adjust that, but you can adjust the exact amount if that's switched.
If that's switched. And what you would do, and you're only going to adjust it for that one specific property.
Specific.
Okay. And then, and so the addendum would be for that one specific property. Okay. All right. So the next portion down of section 7, this is additional fees. They initial beside any that apply. Okay. The first one is bonuses. Okay. Buyer agrees to allow broker to accept, in addition to the broker's fee, above a bonus offered and paid by seller of blank percent of the gross price of the property or flat fee amount. If no bonus is offered, this selection will not apply. If you feel that there is a possibility that they end up purchasing something that may have a bonus, you need to go ahead and have this filled out at the very beginning when y'all are doing when y'all are having the conversation. Especially if you think that they may be interested in new construction, but you can also do it for everybody, period. Okay. Because if there's not a bonus offered, it doesn't apply. But if there is a bonus in there, it states by law that the buyers have to agree in writing that you can take the bonus. Now they're saying it has to be done at the very beginning when the buyer agency agreement is being signed. Okay. Because if you don't have this section filled out, they purchase a home and you find out then that there is a bonus, which in some cases, like if it's a resale, you may not know ahead of time. But if you find out that there is a bonus, you haven't filled out the bonus section on the buyer agency agreement, there's nothing there, you can't accept the bonus.
So what do they, like, what's the bonus that like?
Because you have to disclose everything that you get paid, and a bonus is part of your pay, and the
No.
buyer has to agree to
I
it.
understand that part, but like, we used to be able to, just go and say, like a new construction and there was a bonus offered, you'd be able to go back, add that in, have them initial and be able.
At this point now, they want to make sure that you disclose every single possibility from the very beginning.
And if you do disclose, you talk to them about it, but you don't know what they're going to like.
In this case, what they're doing with the bonuses, and that's why they have this sentence in there. If no bonus is offered, this selection does not apply. Okay. But you're still going to you can either fill it out for everybody, or if you know from what they're looking at, there may be that possibility that a bonus could be given. You're going to fill this out. Okay. You're going to put in as far as percentage. I know some builders will give like 1%. Some will do 2%. Some have a sliding scale depending on how many you sell with them. So estimate that on the high side.
Meritage often, I know they will go up to 10,000 bonus. I've never heard one more than that, so that's just what I put in.
Yeah. So, I mean, as far as like the percentage wise, because there are some builders that do percentages, estimate on the high side. And if they're one of those that do like, okay, after you've sold so many, then you reach this level, whatever that level is, put that percentage in there.
Okay.
And as far as like for the flat fee part, because some of them do percentages, some will do just a flat fee, then you would put what the higher end of that would be. So if you have $10,000 in there, but the bonus is only 1,000 because it's less, you're fine.
Now, if I put 10,000 as a flat fee and they're offering 1%, and 1% comes up to like 3,500, am I covered because that's less than the flat fee? Okay.
Yep.
So can we fill both spaces?
You
So we
can,
can do percent and.
because it says or.
Okay,
It's percentage of gross purchase price of the property or flat fee. Okay, so you can do both. You can do both.
You can do like 3%.
You can do both.
10,000.
Yeah, you can do 3% and 10,000.
So, question with that as well, so, like, I know like Great Southern Homes, they were,
Mm.
they're offering 4% to buyer's agents now. That, and again, and say you have a 3%.
If you have
buyer
a 3% buyer agency and you have a 1%
would
for the
that-
bonus,
Right,
that covers you.
okay, that's what.
okay,
Say
So
okay.
you're still covered.
3% there and 3% for the bonus, that would still cover.
You're covered. Yeah.
Okay, because that was my question, it's not like they're offering an extra percent as a bonus, it's just what they're offering.
Mhm.
So
You're covered.
it's still covered, okay.
Yep, you're covered. Okay. And
Okay,
again,
great.
and make sure the buyers understand. It's like, listen, if they go buy a resale and there's no bonus on it, or the market goes like it did a couple years ago, where new home constructions, they weren't given bonuses because they had so many people walking in. If a bonus isn't given, that they're not going to have to pay you the 10,000, or they're not going to have to pay you the 3. If there's not a bonus, it doesn't apply. Okay. So if you have to highlight that for them, highlight it. All right.
Now for bonuses, I tell my clients that I try my hardest not to find out if there is one until they're ready to write an offer, so that I'm not biased. I think it's okay to say, because I don't want them thinking I'm seeking new construction as a bonus to try to show them that.
Yeah. I mean, you can still tell them that. Yeah. And I mean, and as an agent too, it's up to you what if a bonus is being offered. It's not granted, the buyer has the final say in whether you have it or not. But you as an agent have the choice of, okay, I would rather see this go towards a credit for the buyer. I'd rather see them like maybe put it towards upgrades or something, especially with new construction if you can. If you're giving it to them like as a credit towards their closing costs or as a credit toward upgrades, let me know. I have a a template that I have to send in to the builder to say that it's okay that happens. And all you have to do is you just let me know. It's like, hey, there was a bonus with this, and I'm giving it to them, or I'm giving part of my commission towards them. And you let me know. I have a template for it. Plug in a little bit of information, email it over, and there you go. But I mean, your agents, you are able to um decide how you run your business. Okay. And it's your choice. I'm not going to tell you you have to take every bonus that comes your way, or you have to give every bonus to your clients. It is totally your choice what you do. Okay. All right. Moving on to the next one, retainer fee. A retainer fee, blank amount, due and payable upon the signing of this contract. This fee shall or shall not be credited against the brokerage fee. And there should be little boxes here. On the final draft, that should be there. Okay.
When.
Retainer fee.
Your experience, have you seen retainer fees?
I've seen a couple. And again, as an agent, it's your choice whether you want to charge them or not. The way that we would handle him here in the office is because the retainer fee is due when they sign this agreement. Okay. They're going to pay you pretty much by a personal check. And it has to be made out to Realty One Freedom. Everything has to run through the office. Okay. So you're going to bring that check to us. We're going to deposit it. Because it's a personal check, we are going to wait 10 business days to make sure that it clears their account and then it doesn't get charged back. Okay. Once we know it is cleared, then we'll process the check we will keep 10% as the processing fee. You'll get the rest. Okay. Now, when you get them to closing, that 10% processing fee that we charged is going to be credited towards your transaction fee. Okay. So say they give you a retainer, you negotiate a retainer fee of $300. Okay. We're going to keep $30 as the processing fee. You get them to closing, that $30 that we kept for the processing fee will be credited towards the transaction fee that you pay us. So you'll get it back. Okay. If you decide to do that. Okay.
No, retainer fee is not like you can only work them. That's just they're retaining your service.
They're retaining your service, just like you would with an attorney. You're retaining that attorney's service where they charge a retainer fee. The biggest one where you see retainer fees is with attorneys, but you can do it here.
So
No.
what would be the benefit of doing a retainer fee? Like, why would you?
My first thought was first time home buyers, we're gonna drive you all the way upstate to see, wanna see.
That's possible.
Serious.
Yeah. So some of it do it to make sure that their gas is paid
They're
from
committed.
drive, or they're
Even committed to working with you, kind of like.
Yes.
Right.
Or at
Yeah.
least a membership fee if you. Yeah.
kind
Or
of,
if
yeah.
I go see 20
Mhm.
houses and not actually buy one, at least my gas is paid off.
Mhm. Some agents will do that.
No.
Okay. Next one is the admin fee. Okay. Buyer shall pay broker an admin fee of blank amount to be paid. Now there's two choices here. I only want you to choose at closing. Okay. The first choice is no later than so many calendar days. No. Okay. It is to admin fees are to be paid at closing, and it needs to be on the closing paperwork. Okay. So it needs to come through the attorney's office. Okay.
What's, again, what would be a reason to charge administrator?
Some will charge it that way. They're getting 100% commission back. Some of them some people charge an admin fee based on the transaction fee that they're going to have to pay the office. Some do a flat fee across the board for everybody. Okay. While we're talking about this front, if you are going to charge retainer fees and or admin fees, okay, make sure you are consistent with it. If you charge one, you charge them all. Okay. If you charge a retainer fee to one, charge all of your people a retainer fee. If you're going to charge an admin fee, charge everybody, client or customer. Same for retainers. Okay. Because from the commission, what's going to happen if they come in, they do an audit, they pull one of your files, they see that you charged an admin fee or a retainer fee. That's automatically going to throw up a red flag to them. So they're going to pull more of your files and they're going to see, okay, did they charge everyone else or the others? Okay. So say I charged Entity a retainer fee on mine. They're going to pull my files for you and for Lucy. And they see that I didn't charge Grace, but I charged Lucy.
It'd be like.
Then it's, yeah,
So
you
then-
better have a good reason. I better have a good reason for why I didn't charge Grace.
So then really what we talked about, first time home buyers,
Yeah.
then you really wouldn't work,
Yeah.
because.
If you tell them it's like, okay, first time home buyers, I do this for. You have to have a good you have to be able to explain why.
Yeah.
Okay.
You can do first time buyers, but you can do it for every
First time home buyer.
Every first time home buyer. Okay. And also the amount that you charge, be consistent with that. Okay. With a retainer fee, I would say if you're going to charge it, charge everybody the exact same amount. Because again, if they pull your files and they see that there's different amounts, you need to explain why there's different amounts. Why did Lucy get charged $200? Why did Entity get charged $100? Why did Grace get charged $500? Okay, you would have to explain that. So it's easier to just charge everybody the same when it comes to retainer fees. Okay,
Again, I mean, it's your business.
it's
right?
your business. If you
Can,
don't want to charge them retainer fee, then don't charge a retainer fee.
right, but again, maybe, get some that you don't charge a retainer fee. Maybe maybe they're your relative and you're just, not charging them.
As long as you can explain why, and it has nothing to do with any of the protected classes or anything or any type of discrimination, you're fine. It's like, okay, I didn't charge Lucy a fee because she's my sister-in-law. Okay. That's fine. That's a good solid explanation. But you can't say, well, I didn't charge Lucy the same thing that I charged Grace because I didn't like Lucy. So I wanted to charge her more. That better not be your excuse, because not only will you get in trouble with them, you're gonna get in trouble with me. Okay. But be consistent. And if you are able to explain the differences, great, you're fine. But if there is not a logical explanation for why, then no. Okay. Admin fee. When it comes to the admin fee, you can charge, if you're going to do that, either charge everybody the same or be able to explain why different ones. Okay, I charged Anity this amount because she bought a house that was only 150,000. I charged Lucy this price because she bought a piece of land that was only 50,000. Okay. So again, those are solid explanations. As long
Would
as you're able
our,
to explain it and have a logical explanation for why there's a difference, you're fine. Okay.
so would our transaction fee schedule be a legit answer?
Yeah, because that's based on the sales price of the property.
Okay.
And you can show that this is what it is. Okay.
Mhm.
It's this amount for this. So this is how I based my admin fees on.
Mhm.
Okay. As long as you can provide a logical explanation, you're fine.
Okay.
But if you decide that you're not going to charge either all or nothing, make sure that you can show a pattern and you can show reasons why. Okay.
Mm.
That's all I'm going to say about that. I'm not going to say you have to do it or you don't have to do it. Just be able to explain and have a good solid explanation. Okay. I mean, if something happens and you get caught up for it, I mean, I'll go in there, I'll fight for you, even if you're wrong. We'll have a lovely conversation afterwards, but I will still fight because y'all are mine. Okay. Y'all are my kids. Y'all are my people. But yeah, be prepared that we would have that conversation afterwards. Okay. All right. So this next bottom here under admin fee, if you are charging the admin fee, then you need to check one of these three off. Okay. There'll be boxes beside them. Okay. Sole fee. This is the only fee due to the broker from the buyer. It's credited. It'll be credited towards the broker fee as described above, or not going to be credited. If you're not charging an admin fee, you don't have to worry about that section. Okay. Okay. This one is not has not changed, but pardon me, and I apologize. The lovely Bradford pears are starting to bloom, so pollen's out. Yay. So I highlighted this one because when I'm doing the QC on especially in the buyer agencies, this is the number one thing that is missed. Okay. This says direct seller to buyer broker compensation. Buyer does or does not authorize broker to request that the broker fee be paid in whole or in part by the seller to broker at closing. Okay. You know, they're going to want to choose does. Okay. But there will be a little box here and one here. You can vaguely see the outline of it, but you need to check off one of those. Okay.
I feel like they need to make the box bigger. So I was gonna scroll back.
Yeah.
I always want to.
Yeah.
And they're kind of hidden too.
Mm-hmm. And especially before, because it was kind of, there was all this writing and then there it was, and then more writing. So it was easier to miss. Now it is a little bit closer to other stuff. So maybe not as much, but it's still there. Okay.
Can I ask just back to the administrative piece?
Mhm.
So with where you choose one of those,
Mhm.
if it's an administrative fee, say if it's like for a transaction coordinator, it charges
Mhm.
$300.
Yeah.
Would that, it would be the not credited because it's
Mhm.
something separate
Yep.
from, well, this is, we're talking about the commission, right?
Yep.
It's part, like, the
Yes.
fee that I'm charging is separate from.
Yes.
Okay.
Yep.
So that's, so again, or say if you did the whatever, transaction fee,
Mhm.
that again, is that considered separate with the transaction fee or that's? considered
If you
part?
do the not credited, that's saying that that's not going to be credited towards your broker fee, which is the up here at the top, the whatever percentage or the
Yeah.
flat fee. Okay. That it's not going to be credited to that. You can choose credited to it if, say, they're paying an admin fee and the other side is only paying 2.5%.
Mm.
Or 3%, you can say that, hey, yeah, that is credited towards what I'm getting. So if the other side's only paying 2.5%, you have this for 3. You can say that for not whatever, say $400 that you're charging will go towards that extra 0.5% that you weren't getting. So it'd be credited to it. So, I mean, you could,
And then
if
the
you wanted to,
The whole fee is just,
that's all that would be due from the buyer to the brokerage, period.
so it eliminates the whole compensation,
That's all the buyer would be responsible for
is the administrative,
is the administrative fee. If it closes,
so no.
they wouldn't be
percentage.
paying anything else towards that commission. Okay.
So
Towards this here. You could still have your percentage up, you could still have, say, 3% up here, but that's the only part that the buyer themselves would actually be responsible for. Now, if you find a situation where the seller's not willing to compensate a buyer broker or not willing to put it in the contract, then guess what? That admin fee is all you're getting.
Say that again.
And if it's a situation where the house that they decide that they want, the seller is not willing to pay buyer broker compensation and they're not willing to negotiate it in the contract by way of concessions, and you choose sole fee, that admin fee is the only fee that you are getting. Okay.
Mhm.
And remember,
Wow.
you cannot steer them based on what they're willing to pay, because if you steer them, guess who the possibility of getting sued is and sanctions with the commission and all kinds of lovely bad stuff. Okay. So if you're going to do it, just make sure that you understand how the retainer fees work, how the admin fees work, and be consistent. Okay. All
I think I'll just stay away from them.
right. So, and again, and I only highlighted this part for a protection period because now it's moved to a separate page. It may be, all right, this is your protection period. So after this expires, if they go back and they try to negotiate a contract that you showed them the property, if it's still within this protection period, we can go after them for your fee. If this is still valid, if you have a long enough protection period in there. So in my experience, I never put less than 60 days there.
60. Okay.
Some agents put 120.
Is there,
Not us.
yeah, say, is there any way you can get in trouble for putting too much or something?
Mm.
60 or 90.
Don't put over 365.
Oh, yeah.
But yeah. Okay.
Well, then at that point, you should just have a buyer agency.
You should just do the buyer agency for the full year. Okay. All right. All right. The last change on the buyer agency. Now, this part down here is copyright. This is on every single form now at the bottom. If it's one page, it's at the bottom of that one page. If it's a multiple page document, it's on at the bottom of the last page. Okay. Says this form is copyrighted and may only be used in real estate transactions in which the realtor below is involved as a real estate licensee. Unauthorized use of this form may result in legal sanctions being brought against the user and should be reported to the South Carolina Association of Realtors at, and then their phone number. Okay.
So people genuinely stealing this form?
What? What do you do with it?
That was my thought, like, what do you do with that?
I don't know.
What, yeah.
I mean, I don't know. I don't know why some people do some things.
So,
So you have to fill out your name, your phone number, and your email. Okay. If you have a TC that's working for you filling out this paperwork, they need to fill in your name. Okay. The agent that is preparing it, sending it, is who needs to be down there and the reason it has to be your name and not the TC is because it says the realtor below is involved as a real estate licensee in the transaction. Okay. The ones that are involved in the transaction, when you look at the sales contract, the names are the buyers, the sellers, listing agent, buyer agent. TCs aren't listed on there. Okay. So it has to be, so you have to fill out the bottom of it. If you do not, I will reject it and send it back to you. You have to fill this out. Okay.
it's a question, why you just, isn't a realtor, they're just a real estate agent.
They really should be. Well, they still need to put their stuff down there. They still need to put it
They
down there.
say they make it very specific.
Yeah.
Which the realtor will.
This is one of those things where that was pointed out to them. So maybe in the live one that drops on Monday, it may just say real estate agent. But yeah, but the agent that prepares it or is the one that's sending it needs to fill that out. Excuse me.
Bless you.
Thank you. But you'll see that at the bottom of every form. Okay. All right, that is the buyer agency form. Okay. The next one we're going to look at is the listing agreement, and this is the big one. This is the one with the most changes. Mm-hmm. Gotta look. What actually called was agents not explaining everything the way that they needed to be doing it. All right. So exclusive right to sell listing agreement. And again, I use say exclusive right to sell because if you use exclusive agency listing agreement, buyer walks up to them, they can negotiate between them and sell it and your SOL. Okay. So exclusive right to sell. Okay. So length of agreement. This agreement will begin on such and such date and will automatically end at 11:59 p.m. on this date. The longest you can do a buyer agency agreement or a listing agreement is 1 year. You can extend it when it gets close to the expiration date, but at any given time, it could only be for 1 year. Okay. All right. So this agreement can only be terminated before this date if both broker and owner sign a release from this agreement, which is Form 250. There is no unilateral right to terminate this agreement by either party. If the listing agreement is going to be terminated, both sides have to, the seller has to agree and the brokerage has to agree.
Is
Okay.
that new in the past, and either one could terminate?
No, but they never actually spelled that out before. Okay. So it has so both sides have to agree. Okay. Now, Form 250, that is the conditional release of listing agreement. On that, seller sign and me, broker in charge, has to sign. It's the same thing on the conditional release of buyer agency. I have to sign. Okay. Because technically your buyer agency agreements and your listing agreements are with the brokerage. It has to be me that signs it. Okay. Other forms where it's set on the buyer agency agreement, you can sign as a representative of the brokerage. Same on listing agreement. The only ones that I have to sign myself is the notice of termination I need to sign, and then the conditional releases of either buyer agency or listing agreement. Okay. Everything else y'all are able to sign as a representative of the brokerage, because otherwise that's what I would be doing all day long and wouldn't have time to do anything else. Okay.
Commission agreement, where it says the broker, do you have to sign or can we sign as a?
Y'all can sign it as a representative.
I'll stop.
So,
But I could send it in there.
yeah, you can, yeah, you can sign them as a,
It does. I'm always like,
Mhm.
I'm just gonna be safe.
Why do they do that? Why can't they do broker or representative?
because some of them do now. Some of them have said either broker or
Yeah.
representative.
Or like
Okay.
license. Yeah.
But it's literally it's up to each individual big how much involved they will or will not be. If there was only 5 of us, then yes, send it to me, I'll sign all of it. At 100, I wouldn't get anything else done because that's what I'd be doing all day long. Okay. All right. So, and part of it too, why it says broker, because if you look up here at the top in most of them where it says like buyer agency and listing agreement, where it says real estate company, herein called broker, that's why it says broker. Okay. The conditional releases actually say broker in charge. They specific. But on everything except the termination and the conditional releases, y'all have permission to, I give y'all permission to sign. Okay. All right. So the next part is change section 3. This is the same as on the buyer agency side where it has talks about the disclosure they acknowledges receiving the disclosure brochure, and owner acknowledges that after entering into written agreement, dual or designated could come up. Okay. So they initial beside both, and then dual agency and designated agency were split up again, so that it breaks it apart, so it makes it easier for sellers to understand. Okay. So then they just initial beside their choice. Okay.
So why do that extra line if it says might request a modification? So if they already mark that one, say they initial that one, then if there is a dual agency agreement, then should we just, you know what I mean? Sign it, but why are we being redundant?
Well,
Initially there, initially there.
This first one where it says owner acknowledges receiving an explanation of the types of agency relationships is redundant because they have to sign the disclosure
Mhm.
brochure.
Right. I mean,
Yeah.
I understand that.
There's lots of redundancy, and this just goes back to lawyers. So,
I think it's just,
and again,
my parents are in a lovely situation right now. I'm not really, I told them I won't touch that, but,
very smart.
they're having to go back through and check their paperwork to see like what they initialed by and what they didn't for, dual agency and that sort of thing, and some of the lines they did and some of the lines they didn't, but they did find the disclosure, so it's like, well, the redundancies can sometimes cause issues, and sometimes they can help by having you reinstate
Yeah.
4 times, so you understand.
You understand. Yeah. Mhm.
Are they in a dual agency now, but is that what's happening with
Almost.
Mhm. So then so section 3 of this agency disclosure is the same thing that's on the buyer agency. Okay. All right, section 4, list price. Whereas before you had that section 2 where it talks about the list price and it's this big long it's one sentence now. Okay, listing price. The listing price will be blank amount. And you only have to put the numbers in there now. There's no more having to write it all out. Okay. It's just the numbers. Okay. So
How come they did it away with the letters, like with the words, because
Alright.
like in the bank, they'll look at the whatever's written, not what's the numerical value.
Yeah. In court, from my understanding, in court, if it's handwritten, you have to have the written because they'll go by the written over the numerical.
Right.
If it's typed, they'll go by the numerical.
It's over the written.
But for whatever reason, at this point, they just are putting in the numeric. Sarah, is that your hand? Oh, okay. Sorry. Okay. Not sure what that was for at first. Okay. And so any adjustment to the listing price will be agreed upon in writing between the owner and broker. Okay. That's your MLS change form where you're changing the price. Okay. All right. So number 5, this is the big change, okay? Listing broker compensation. Then notice, the broker's compensation for services rendered is solely a matter of negotiation between broker and owner and is not set by law, fixed, controlled, suggested, recommended, or maintained by a board/association, the MLS. Any person is not a party to this listing agreement. So, and then next page, broker's commission. Listing broker compensation will be paid by owner in U.S. funds at the time of and as a condition of sale completion. Listing broker compensation is, and you check one of the 3 options, okay? First option, exactly this amount. So if you're doing a flat fee, fill in number 1 and you fill in the amount, okay? Option 2 is the percentage of the gross purchase price. Third option is other. So if it's, say they're only doing, they'll give a 0.5% plus a flat fee, or however they're going to do other. If it doesn't, if it's not all set price or not all percentage, then other and explain. Okay. And this is only your compensation as the listing agent. Okay. You're only negotiating yours. Okay. The seller will negotiate buyer agent in the contract or through a separate compensation agreement when an offer comes through. This is only for your side.
Okay. So only for the listing agents portion, is it okay to discuss what maybe to expect buyers?
Oh, yeah.
Okay.
Yeah,
You
that's
just-
further on down. You just, it's no longer part, because before you had total commission, which is yours, and if they were willing to pay a buyer broker, yours plus that one for total. And then you broke it down to, okay, this is what would go to the buyer broker. Now it's, you are only negotiating for your compensation. Okay. All right. So your protection period, protection days. Okay. Admin fee is the same as with on the buyer agency. If you charge 1, charge them all. Be consistent on the amount that you charge, whether it be everybody 1 fee, or if you do different fees, make sure you have a good explanation. Okay. And it's always at closing.
Now, question, say you haven't been charging them administrative fees, you know, your past clients, and now you say, you know, from now on, I'm gonna be charging them.
You can do it now, because you can say, based on the changes, law changes and form changes, I decided to start doing it because it's adding more work on my side. So that's a reasonable explanation for it. I mean, the law changes are making more work. So, okay. So that is section 5. Section 5 only deals with your compensation. Okay. Now where we're getting to now section 6 talks about additional compensation for assisting unrepresented buyers. Okay. This is buyers that come to you, say, like, they come in, you have an open house and they come in. They do not have a written buyer agency or a written transaction brokerage with another agent. They are totally unrepresented. Okay. So this section gives you the ability to negotiate with the seller. Now, it has to be done upfront when signing the listing agreement, that if this becomes the case, that if an unrepresented buyer presents and they want to make an offer on it, you're going to handle them as a customer. You're going to keep them as a customer. You're still going to do a transaction brokerage agreement, because you need in writing what services you are providing them and what you are not providing them. They need to understand that. Okay. Some agencies say you don't have to do that, because technically for a customer, all you really have to have is the disclosure of brokerage relationship signed. I'm saying I want y'all to get a signed transaction brokerage agreement, because again, it states exactly what you will be doing for them and what you won't be doing for them. So there is no other way to interpret anything else. So they cannot come back and say later on, well, I thought Anity was going to do this for me and I thought she was going to advise me on this and she didn't. If you don't have that, if you don't have a transaction brokerage agreement signed or something in writing stating specifically, this is what I will do for you, this is what I'm not doing for you, guess who wins that argument? Consumer, every time. Okay.
Sellers do the transaction brokerage agreement. Does that count as dual agency? Because it's not even
No.
signed.
Because a transaction brokerage agreement is still keeping them as a customer. Okay.
So
They are still receiving customer service as a transaction brokerage agreement. Okay. Client is an exclusive right to buy buyer agency agreement. So they are a client at that point. Okay. Transaction brokerage equals customer. So even though it is in writing, it is still a customer. Okay. But it spells out specifically this under transaction brokerage. These are the services that I get. These are services that I do not get. Okay.
So when would you use a dual agency?
If you already have a buyer agency agreement with the buyer.
Okay.
If one of the buyers that you're already working with and you have an agency agreement with them, they see your listing come on the market and that's like, oh, that would be perfect. That's a dual agency. Both are clients. Okay. Remember, dual agency, two clients.
Right.
Same agent represents both sides. Designated agency, different agent, one agent for the buyer, separate agent for the seller,
Same broker.
same BIC.
Yeah, same broker. Yeah.
Okay.
what about the client with one agent? Customer, different agents, same big.
They're a customer, so it doesn't count. In order to have designated and dual, all parties have to be clients.
That's all. I just have a situation right now.
Yeah.
I was
If
about-
one is a customer, it's not dual or designated.
Okay.
So again, if somebody walks in unrepresented, they like your listing, they want you to do it,
Mhm.
then you just sign the transaction brokerage.
Transaction broker. And it's in your best interest to try to keep them as a customer because there is less liability. Okay. Because you've already had conversations with the seller and you've already given them advice. Once you become a dual agent, at that point, you have to actually start treating both of them like customers.
Now, why if they insist on being your customer, I mean, your client?
At that point, then that's your choice, whether you decide you want to do dual agent or if you would rather move them to into a designated agent capacity where they would be represented by another agent in the office. That's still your call. Just because they want it doesn't mean you have to do it. Okay. So, but it is actually in your best interest for someone like that to keep it as a customer because there's less liability. Because imagine having the conversation with your seller, okay, I now have, it's like when we first started, it's like this, I tell you everything that I'm going to do for you and how I'm earning my commission and I'm advising you along the way and everything. Well, now you're in a dual agency situation. You can no longer advise either side. So you have to go from being able to advise them and then being used to that to, well, at this point, I'm pretty much a secretary for both sides. Y'all tell me what you want to do. So that's my personal feelings on dual agency. But I'm not going to tell you y'all can't do it yet. That may come. But just if you can keep them as a customer, keep them as a customer. Yeah. So when if this situation happens for an unrepresented buyer, okay, you can negotiate with the owner because there will be extra work on your side, okay, for an additional compensation of a flat fee or an additional percentage. Okay. Fully negotiable between you and the seller. Okay. only if it, in this specific situation, would it apply though.
Can
Okay.
you just leave it blank if aren't going to help them,
Mhm.
like you just refer out? that
Yep.
person?
But why? So if you're, that might happen, you still would want to fill it out.
Yeah. If during the conversation, if during the listing presentation and you're talking about this and they flat out say, no, I don't want, then don't initially, because it doesn't give a choice on agreeing or not agreeing.
Mhm.
So in that case, if they don't want you, if that happens and they don't want to pay you extra, and that's the terms that y'all come to, then they wouldn't initial either one of them, and you wouldn't have to worry about filling it out. Okay. 7, this buyer broker compensation. Listing broker is not authorized to compensate any other buyer broker. Owner can choose to directly negotiate compensation with the buyer broker, Form 120, which is the compensation agreement, or can instead choose to directly negotiate transaction costs with the buyer. Mhm. So they can negotiate compensation on compensation agreement, and it's a, or choose to directly negotiate transaction costs. That's concessions, that's closing costs in the contract. Okay. Number 8, owner concessions. Notice, owner concessions are not required or fixed by law. Remember, anytime you see concessions, that means we're talking about closing costs paid by the seller on the buyer's behalf. Okay. The amount of any owner concession is fully negotiable. Any and all concessions will be negotiated under transaction costs in Section 6 of SCR Form 300, 310, whichever agreement to buy or sell that you're using. Okay. A concession is an agreement for the seller to pay some amount towards the buyer's transaction costs. All others, which may include request for buyer's broker compensation from owner or owner concessions, will be presented to owner in a timely manner for review and negotiation. Mhm. And then owner, and there will be check boxes here, agrees or does not agree to allow broker to advertise the owner's willingness to negotiate for owner concessions. Okay. That sentence is still in the current listing agreement. Okay. So the owner checks off in Section 8 whether they agree that you can or cannot advertise their willingness to negotiate for concessions. Okay. If they choose agrees, again, that is not locking them in to having to pay concessions. That is just saying that they are willing to negotiate. And the person that decides that is the seller. Okay. An offer comes in and it's low, they can say, okay, I'll accept that offer, but I'm not going to pay anything towards the buyer agent compensation. They can do that. Mhm. That's open.
Number 7 is just specifying that as a listing agent, I am only negotiating with the seller of my own commission. But then if we get an offer and they're asking for buyer's agent commission, I can help my seller negotiate that as my law.
Yeah. Yeah. So in the listing agreement, the only compensation that is talked about, actual amount that is talked about in the listing agreement, is what you as the listing agent are getting. Okay. And then 7 and 8 talk about that one, we're not paying a buyer brokerage anymore. And that if that's going to be done, it has to be negotiated either through the compensation agreement or through the sales contract by way of concessions. Mhm. And then it goes into a little in section 14, and it talks about the residential property disclosure statement. It goes into a little bit more detail about it. So just go back and read those sections. I'm not going to read all of that. Y'all can read that on your own. Okay. And they did take out some of the under section 18 where you had the option 1 going in MLS, option 2 doesn't go in MLS. Because whereas before you had to check off the seller agrees or does not agree for marketing and stuff, they took part of that out. Okay. Lockbox. since it's kind of down here by itself, don't forget that one. Even if it's on land, you still have to do does or does not agree for a lockbox.
And the number 18. No, you don't have to write word you input the property, right? Which
It says right here into the following MLS listing services of which the broker is a member, but they didn't put a blank there.
Yeah.
So again, on the final, the live version that drops on Monday may have that in there.
Okay.
The draft does not, but you never know. So, but just be prepared that you may still have to do that. Okay.
What is the point of them keep putting like the lockbox option for land, or, you know, when you do a lot agreement?
In case it has a gate on it and they want a lockbox on the gate before they can enter the property. I don't know why they do some stuff the way they do.
We already lost the land and I was like, what? Right.
Mhm.
Yeah.
Right, because
Yeah.
that's the thing, is they,
Yeah.
and usually it happens.
Most
they've
of- yeah.
already- They found the address, they've already walked it,
Yeah.
and then they contact.
And they just want you to write it up, okay?
Yeah.
Okay. All right, and the last change for the listing agreement is the lovely copyright at the bottom. Okay, your name, phone number, email. Okay. That is the listing agreement. Okay. The next one, I have the compensation agreement. Yeah,
And
because
I'm assuming they completely eliminated the buyer's brokerage now, there's.
yes,
that
it's just now there's not
Option.
currently this. Excuse me, this is going to be a fun allergy season. Currently you have two compensation agreements, one that says listing brokerage to buyer brokerage,
Mhm.
and then one that says seller to buyer broker. As of Monday, it's only going to be seller to buyer broker.
Thank goodness.
Okay. Yeah.
Way more confusion than it should have on the first switch.
Yep. Yeah, exactly. So now it is just seller to buyer broker. It's still going to come through you as the listing agent, but it's directed at seller to buyer broker. Okay. And the only thing that changed on it is the copyright. And I'm pointing that out on every form. So, because I know there are going to be agents out there that forget it. And I'm going to have to say, you forgot it. Okay. All right. What's next? I know some of y'all think that I'm a nag when it comes to paperwork, but if you ever have to go to court, okay, the judge is going to review paperwork. If they see mistakes on the paperwork, it doesn't matter how solid of an argument that you have, that could lose your case. So we are not going to, I'm going to make sure that we do not lose based on paperwork. Okay. When I was first trained as an agent by Karen, she is our former broker. She trained me how to do the paperwork first. Okay. So I am a stickler when it comes to the paperwork. Y'all can cuss at me or complain about me as much as you want, but I'm not going to change that. Okay. Because there is a reason behind it. All right. So compensation, the only thing that changed is the copyright.
Can you go back up, so it says. The seller to buyer's brokerage.
So you list all of the sellers and then the buyer brokerage name. So this is going to be between the seller and the buyer brokerage. No longer the listing brokerage and the buyer brokerage. So it's going to be directly with the sellers. And this,
Of the seller instead of,
mhm,
so you still
Yep.
have to do the buyer's.
mhm. If they do it by way of compensation agreement, it's going to be this one. Okay.
So why did, but they still want buyer's name, right?
Because it's going to be specific for that one transaction. Mhm. You're not going to have a blanket compensation agreement in this case.
Well, I figured the property address would be the one
No.
that shows the specific.
Okay. Out of the contracts, I'm only going to show the residential. All of the changes are exactly the same on residential land, all of that. You could tell which one I ended on last night. So let me get to where I can. Zoom in. Here we go. Okay. So agreement to buy and sell real estate. This one's the residential, but all of the areas that changed are the same on each of the contracts, except commercial. Commercial in a few months is going to be changing. So they'll have a updated contract then. But we mainly do residential. Okay. All right. So not going through every single one of them. Okay. Change it. Earnest money. Section 5 changed. Whereas before you only had that little paragraph in here that was, of course, in bold, all caps, everything. Now it is earnest money being held by a real estate brokerage firm. And as you can see by me writing over here, we do not hold earnest money. We do not have an escrow account. Okay? So we do not hold earnest money. So that paragraph, this big one right here, does not apply to us.
We just blanket.
So leave it blank or you can put a 0. Okay. The one that does apply for us is earnest money being held by law firm. Okay. So this is the one that you explain to them. Okay. If parties agree to a law firm serving as escrow agent, then earnest money deposit can be dispersed in accordance to an escrow agreement, which is Form 517 or 518, which is the release of agreement. Or there is one that is also, it's a release of earnest money, but not contract. So it has to be one of those two forms signed by all parties. Okay. They have to have that in writing and signed by all parties before they can release earnest money. Okay. If it falls apart. Okay. Or a form drafted by the law firm and signed by both buyer and seller. If the individual law firms decide to do that and it's signed, they need to provide us with a copy of it because we have to have it for our file to show that who got it back and how it was dispersed. Okay. The signed agreement for their file, any fees charged by the law firm in settling an earnest money dispute will be included in the escrow agreement signed by the parties. Okay.
On the old one, it used to be all just in that one.
It used to be just this right here. They added this part. So they differentiated between it being held by a real estate brokerage firm or being held by a law firm. Okay. There are some brokerages that do have an escrow account and some that will hold earnest money. We're not one of those.
So, did it say real estate brokerage up there?
Yeah, it says held by if earnest money if being held by a real estate brokerage firm.
And that was on the old one, because I thought.
On the old one, it did not say,
Okay, that
it
was gonna
didn't
say-
have that.
I was gonna say.
It was-
I never saw a real estate
No.
brokerage firm before.
No, it was just this big paragraph right
Yes,
here.
Yes.
That was the only thing that was on the other one.
Right. And
On the
that's where-
new one, they have it broken up.
Right, and some attorneys would charge a fee and you would put in that fee, and then some would, okay,
Mhm.
I was gonna say, I'm like, I'm sure we did.
And when it's being held by the law firm, it's their responsibility to notify the buyer and the seller what fees or whatever they would charge if they have to go to court.
So, but we used to write down an amount there.
Yeah, because it didn't differentiate between buyer brokerage or the law firm. Okay. Because that amount that we put in there, it was to cover whichever escrow person, because if the buyer and the seller could not come to an agreement on how the earnest money was going to be dispersed, it would have to go to interpleader. To do that, whoever the escrow holder would have to go down to the magistrate office and file an interpleader for it to be seen by the judge. Okay. And that amount we put in there covered the cost of them having to do that. Okay. Now, because that only falls under the real estate brokerage holding the earnest money, We don't have to do that because we do not hold earnest money. Okay?
So they don't need to sign anything, you just.
They don't need, you don't,
You
you can
sign.
put a dash in there, you can put a zero in there, or you can leave that one blank if you want to. Okay? Because that only applies if if that brokerage is holding it. We don't hold it. Okay? Yeah. So that one. And then this section did not change. This is section 6. This is if the buyer broker compensation is being paid through concessions, through seller paid closing cost. Okay. So section 4, it's the main section is section 6, transaction costs. Okay. And then number 4. Okay. At closing, seller will pay buyer's transaction costs not to exceed. And this is where you put the total amount of the closing costs that they're paying. Okay. So total amount, that would be if you were trying to get your your buyer agent commission through the concessions, you are going to have already had the conversation with the lender or seen on the pre-approval, pre-qualification that they have how much they need for financing, how much they need for their closing costs. Say it's $5,000. You figured your compensation is $5,000. You add those two together, get $10,000. You put $10,000 here. Okay. This one right here, and it's not letting me highlight anything, but right here, total. Okay. This one is where you're going to put the amount of what yours is. Okay. So in this example, you have the 10,000 and the total up here. Your part of it's going to be 5,000. You'd put 5,000 here. Buyer initials, seller initials. Okay. And then the law firm will do the math. Okay.
Now, if your buyer wants to ask for closing costs and obviously your commission to be paid from the seller, can you just put closing costs there and then send your commission through the commission agreement, or do you have to add the two?
Do two.
You can do one or the other. You cannot do both anymore. Okay.
What do you mean? Sorry.
You either have to send it as commit on compensation agreement or on the
On the contract?
contract as far as concessions. Okay.
And the reason to do a compensation agreement would be if your buyer can only ask for so many total closing costs through their.
Now, I did talk to a lender because certain programs, they are only allowed so much towards that they can get into credit. If your buyer agent compensation is part of that closing cost, they will not count that amount towards what the buyer's credited. Okay.
So you won't.
They will not. According, I talked to Fallon, according to them and Greg, that will not be charged. That will not be counted towards.
So what would
What's
be
going to
best,
that?
just to put it all in the contract, or to put in do the two separate compensation agreement in the contract?
It's either or. It's going to depend on when you're still going to contact the listing agent ahead of time saying, hey, my buyers want to put in an offer. You're going to, and you confirm email address and where you're sending it to. Do you have any other offers? Okay. And does the seller, do they want it sent over on a compensation agreement or do they want it in the contract?
So really just whatever the seller prefers.
Mhm.
The only other thing, the problem that I've run into multiple times is the listing agent doesn't get back to you and you're needing to write the offer, and then they. keep
Then
messages,
what you're going to do
and then-
at that point, then what you're going to do is you're going to put it on a compensation agreement. You're going to make sure that it is checked off on the contract, that it is part of the contract, and you're going to send it.
And my default would be to separate.
Would be to separate.
Representing sellers, they always like it when it's clear what numbers for
Mhm.
what and that's all, so.
Okay, so then
Mhm.
compensation would be, because then,
Yeah.
but then some prefer it on the contract, and that's the thing.
And if they come back and you send it over and you send over the offer with the compensation agreement attached to it, and they come back and they say that they would rather have it in there, then that's a counter offer and you're negotiating. Mhm. Mhm. So the only reason I highlighted this section was to go over that part with if they want it in there, that's it. Okay, it did not change from the way it is right now,
Right.
but it's just, okay. And then if none of the closing costs are going towards the buyer agent compensation, then they would initial beside B. If closing costs are zero, you don't have to worry about option A or B. Okay.
Okay.
If it's zero, you don't have to worry about either one. But if there is an amount other than zero up here, then
Yeah.
option A or B has to be completed. Okay. There wasn't a whole lot that changed on here. Okay, the next big change was section 19, state and federal requirements. Before and currently there's just a little itty bitty paragraph saying that there are some state laws and some federal laws that you have to follow and stuff. Now they have broken them out and explained each one. Okay. So A, South Carolina income tax on non-resident. B, Foreign Investment and Real Property Tax Act. C, Financial Crimes Enforcement Network. That's FinCEN. I'll go more in depth on that when we get to Form 800. Okay. D, anti-terrorism. And 3, general legal compliance. So it spells out each one of them now. Okay. Whereas before you had just like a little paragraph about the size of section 18. But now they've spelled everything out. Okay.
Say anything, or do you want to just read that with your seller or?
I would read through it. Yeah. Just so that they're aware of it. I mean, and it's pretty straightforward with each of them. I mean, it pretty much comes down to general legal compliant party agree to comply with all local, state, and federal laws and rules applicable to this real estate transaction. Which pretty much that's what it said before, but now they added all the extra stuff. Okay. All right. Next one here's it talks about whoops. Some days I love my computer, some days I hate my computer. Okay. Section 25, some of the verbiage changed in this one. Again, it's saying parties direct closing attorney to use settlement funds to collect and disperse compensation to brokers in accordance with this agreement or any separate listing or buyer agreement. Okay. All right. So, section 26, this is the section where there is already section on the current one, but it changed a little bit because they took out one of the compensation agreements and then they added in FinCEN, okay, attachments and other contingencies, terms, and stipulations. If when you were sending over an offer, if you're sending a compensation agreement, if you're sending FinCEN, if you're sending a separate addendum, always check it off on this list. By checking it off, you are making it part of the contract and you're putting it within the four walls of the contract. Okay. So if the seller agrees with what you have, the terms in the contract, and they sign that, but they don't sign the compensation agreement or they don't sign FinCEN, guess what? You don't have a ratified contract.
Okay.
Okay. At that point, it's a counteroffer because they're saying, okay, I liked all of this stuff, but I don't like this. Or if they make a change on the compensation agreement, you still don't have a ratified contract because it's part of it. Okay. So always make sure if you are sending over additional addendums or additional forms with the offer, make sure that you check them off if they're already listed. If they're not already listed, check other and then list what they are. And that makes it part of the contract. Okay. Because I know when everything changed, back when it very first changed, and they said send over the compensation agreement first, get it signed, then send the offer. There was some agents who are like, okay, well, the seller doesn't want to sign until they see the offer.
Mhm.
So you'd send the offer over. They would sign the offer, send it back, but not the compensation agreement. So guess what? You have a ratified contract and you still need to move forward on that ratified contract, but you don't know if you're getting paid or not.
Mhm.
By making it part of the contract, that is no longer able to happen. So it is part of the contract. If they don't sign the compensation agreement and you have it checked as being part of the contract, then what essentially they're saying is, okay, it's a counteroffer. You're still negotiating. Okay, maybe at that point they want it in, they would rather have it in the concessions part instead of compensation agreement, whichever one. So, okay. So in order for it to be a ratified contract, the offer itself, along with all of the attached addenda, has to be completed, signed, ratified, initialed, everything it needs to be done. Okay. And then the last change, copyright. All right. Almost done. I promise, almost done. Okay.
It's one of those days.
Yeah, it's one of them days. Okay. All right. And last but not least, no. Okay. Last but not least, and because this is a federal form, this is required. Okay. This is FinCEN. It is the Financial Crimes Enforcement Network. Okay. The reason this came about is because they found out that a lot of not so nice people were using real estate transactions as a way to launder money. Okay. So the federal government passed this. They actually passed back in January, but it went into effect as of March 1st. Okay.
That includes part of this out. So
Mhm.
if this is part of March 9th, why are we already doing that?
Because they put it out, it went into effect March 1st, but the commission didn't drop in the form until the 9th. Mhm. So-
Who these people are that have that much money to launder. I'm like, just give it to me at this point.
So
You know, I'm,
Yeah.
I'm making my ends meet here. Who in the world
Yeah.
has?
this, yeah,
Like, why is the government just now figuring out?
exactly. Thank
Is this
you.
really that new?
Yeah.
Is what I
Yeah.
think.
No, it's not. So this is going to come into play when you are working representing a buyer and they are purchasing a property, all cash, and they are putting it in the name of a trust or another entity, like a corporation name, LLC name, or a company name. Okay. If it's not going to be in their personal name and they're paying cash, FinCEN is going to apply. Okay. Our job as agents, our job as agents is only to notify the buyers that this is going to come into play and that the closing attorney is going to ask for this information. It is the closing attorney's responsibility to gather the information and submit it. Okay. Not ours.
So the
Thank God.
closing attorney is supposed to send this out?
No, we send this out because we have to disclose to the buyer that this would be in play. And what this does is it explains what FinCEN is to the buyer. Sellers have to sign it too, because this could affect closing. And it actually states that in here. Okay. And the buyer is agreeing saying by signing this, they acknowledge you've given it to them and that they understand the closing attorney is going to ask for this information. And it talks about the information that they're going to need. And they're going to say it's buyer shall within 7 days after receiving a request for FinCEN from the reporting person, which is the closing attorney, they are going to submit the paperwork that they need to. Okay. If they do not send it within that 7 days, closing will be delayed until they get the paperwork. If they never submit the paperwork, it will not close. Okay.
the attorneys already gather all this information before, I mean, I know, they asked for the,
They didn't.
documents, the this, the that, and all that.
They didn't have to submit it to the federal government before.
Oh, they just gathered it, but,
They gathered it and it was part of their documentation and part of their file.
okay.
But they didn't have to submit it to the Financial Crimes Enforcement Network before.
Okay. So then, what are we supposed to now babysit the attorney and make sure they submitted it?
No, that is the attorney's problem.
No, I know, but then they delay the closing, it's not gonna close, and then it becomes our problem, right?
Well, that would be
No.
if your buyer doesn't fill out the stuff.
If you're,
If the buyer doesn't, but
if they don't send the information in that the closing attorney is wanting, then yeah, it's going to delay the closing.
okay, but if they fill everything out and just, I mean, again, if the attorney takes their time to submit whatever it is,
That's on the attorney. That's not on the buyer. It's where the buyer, because they'll probably ask the seller for a little bit of information too. It's going to be on, they have to turn it in within so much time, and it states it. That's why it states in here. If they don't, closing will be delayed, or it will not happen at all if they refuse to turn it in. Okay. So sellers need to be aware of that. Okay. So that's
So
why
what
it has,
question for you?
and hold on a second. That's why sellers and buyers both have to sign this. Our only responsibility in this for this part is we give this to the buyers or the sellers to explain it. By the time the seller gets it, the buyers are already going to have signed it. Okay.
So we don't send it for signature, we just send it for information.
We send this form 800 for signatures. The actual information will be requested by the closing attorney. Okay.
But it will be the same, basically the same information that it used to be in the past.
Pretty much. I mean, they're going to need to see their articles of confederation, who has the ability to sign, who's actually part of the LLC or the corporation or the trust, who all's part of it, who signs and where the money goes and all of that.
So we send it to our buyer, they sign it, then we have to take it and send it to the listing agent and have them.
That would be this would be, because when you're making the offer, you're going to know at that point if they're putting it into a company name or a trust name. So you're actually going to attach this to the contract, because on the contract it is listed in that section 26 free to check off that it is attached.
And then it's on the listing agent to have it.
The seller sign it. Yeah.
Now I have a closing tomorrow. Do I need to send that form? I don't even think I have access to it yet till the 9th, right?
Correct. Because that's not the final version.
Yeah, however, for me, is the attorney sent me an branded explanation of what that was.
Mhm.
Asked me to let the buyer know that that's what that was in their thing, and then they submitted, like they used Wallia, so they submitted it as a task for the buyer. They
Yeah.
submitted everything, they approved it, sent it off, and it didn't delay it.
Right.
And needed to be closed, so.
Yeah.
Okay, right, because I just had a closing just at the February, literally right before this, where it wasn't, and like, it's an investor here, it's an LLC, they purchased it with cash, all that, but nobody, there was not even.
Because it didn't go into effect until March 1st.
Right,
Because it
exactly.
closed in February, it was fine.
Right, exactly, that's what I'm saying, so that's where the confusion's like.
Yeah. Okay, Sarah,
Signs where-
what was your question?
When do you submit it? Right after the, when do you give it to the seller or a buyer? Is that when you have an offer ratified, or, during
When
that
it's
time?
good. If you're representing the buyer, you send it over as part of the offer. You attach it to
Okay.
the contract in section 26 of the, let me go back.
The buyer, what is it? Okay. But this is only for LLC, or is that for even a?
If for a trust, LLC, company name,
Okay,
if it's not going to be in the buyer's personal name, then it's going to apply. Okay.
okay,
This
got it.
is page 8 of the contract. Okay. See here under section 26, attachments, FinCEN form 800 is one of them. So if you're the buyer agent and the buyer is not putting it in their name, is in the trust or company name, you check this off, you fill out Form 800, have them sign, and then you send, then it's part of the offer. And then at that point, when you send it to the listing agent, it's the listing agent presents it as part of the offer to the seller. Okay.
Got it. Thank you.
Okay. And that's FinCEN. The only thing that we have to do is by notifying the buyer, or if we're the listing agent, notifying the seller that, okay, the buyer is buying in this is going to apply. There's going to be additional information that the closing attorney will ask for. And if you don't do
Okay.
it, either delay closing. If you do not send it at all, provide it at all, then there will be no closing. And this is federal law, not local or state commission. It is federal law. There's no way around it. Okay.
Okay, got it. Thank you.
Okay. Any questions about any of it? Because that was the last form I had to go over. I know it's a lot. It's a lot.
We'll have questions as we
Yes.
go.
And remember, I have 2 phones, emails, text, phone calls, Facebook Messenger,
So
if you need to.
We don't need to change anything?
If you already, okay, for any, as of March 9th, if you have a buyer agreement, buyer agency agreement, or listing agreement, and they are already under a sales contract, you do not have to change anything. You don't have to do anything. They move forward as is. Okay. If you have a buyer agency or a listing agreement and they are not under contract, then I have an addendum prepared, depending on whether it's the listing or the buyer agent. And what it is, it's the verbiage, the new verbiage from the buyer agency, or it's the new verbiage from the listing agreement that you would take to your client and have them sign off on. That way you do not have to go back and redo a whole brand new listing agreement or a brand new buyer agency agreement. Okay. But and those will be available to you on Monday.
Is there a certain amount of time we need to get this signed in?
I would say if you can do it before, what's Friday? Whatever date Friday is, next Friday is, yeah.
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 And if we can't get it updated, do we take the list?
Communicate with me. Just let me know.
I have a seller who's not under contract, who's getting married this weekend, and then she's going out of country for her honeymoon.
That's special situations.
Right. I'll sign this. And be like, can you hop on a call so I can explain? So
Special circumstance. Hey, in that case, if you just want to have a quick phone call with her, explain it to her and say, hey, can you just shoot me a quick email saying that, hey, you explained it and I understand, I'll be good with that.
Okay.
Special circumstances, or if you have seller that you know that is going to pitch a fit or whatever about signing something else, just let me know. And then we'll figure something out and we can work with it.
So will you we just ask you to send those addendums to us so we can.
I'll send them out and I'll have them uploaded in SkySlope forms for you.
Now the addendum for the listing agreement, if we've already negotiated a commission amount that includes buyer agent, does it change with the addendum?
Mhm. At that point, it will be letting them know that only this amount, you're only going to be on mine, and that any offer that comes through, then they will negotiate their side.
Which has kind of always been the case, because we agree
Yeah.
on both sides, that's
Yeah.
negotiable.
Yeah.
Right.
And just at this point, instead of it being where you could be from Realty One Group to XYZ Realty, now it's going to be from the seller to whoever the buyer brokerage is. Mhm. I mean, honestly, when everything changed, EXP started that to begin with, that they weren't going to do brokerage to brokerage. It was only going to be seller to buyer agent.
Yeah.
And I mean, that's what it's gone to.
The exchange is those.
So
Like.
you're still going to be negotiating the same way. You're still going to be negotiating to try to get as a buyer agent, still trying to negotiate to get your fee with them, either by a compensation agreement or concessions. That part hasn't changed. It's just the verbiage has changed and they're doing it to make it more understanding.
I I understand.
For-
all.
Yeah.
But do we not, like, does everybody, I feel like this makes it way more complicated. In that sense of like, when you try to explain all these things to your buyer. They feel like all of a sudden, like, there's way more now charges than, you know, even though you're. Doing the same things you're going to be asking, as we've always said, you know, all this, but as soon as you start saying, well, now this changes. They get all panicky for some reason, you know?
Yeah,
Yeah.
existing clients is gonna be tough
Yeah.
for new clients, I'm just saying, here's, plain it as is.
Right,
Mhm.
but
Right.
exactly, if
For
we already
existing.
signed it with it, and they're like, wait, well, I thought, you know, all of that. I'm like,
Yeah.
how's this supposed to simplify? when
I'll
it's-
just say, like,